I'm often asked how I take my work from first responders and firefighters and people who are responding to Hurricane Harvey to litigating attorneys. And in my work, it's all the same thing. Litigating attorneys I like to use as sort of the consummate example of what a high-stakes performer is. I've spent over 10 years watching litigating attorneys in not mock trials, but real trials and real hearings litigate. I've seen really good attorneys and really not so good attorneys. And the really good attorneys are, in my opinion, high-stakes performers. And the way I break that down is they have access to various parts of themselves at will. It's a self-mastery kind of thing. So if you think about it, if you put yourself in the place of a litigating attorney, you're in a courtroom. You are arguing your case. You have to have knowledge of applicable law. You have to have knowledge of what's happened with your client in this case. And what you're using are your frontal lobes. You're using your logic, your analytical thinking skills, and you're also communicating in a way with a judge or with co-counsel or with opposing counsel that is in legal speak. Then, if you are turning to a jury and you're explaining your client's case to a jury, you're talking to non-legal people. So you have to not only change what's going on in your frontal lobes, come out of legal speak and into lay speak so that it's understandable and easy to explain to the jury. There's also something called storytelling. When an attorney tells the story of what happens to his or her client. Good attorneys are able to come somewhat out of their frontal lobes and actually do what a lot of trained actors are able to do, which is come down into their gut. And that's the emotional center. That's where we feel things. And if they're very high stakes performers, they can drop down into this gut level and they are able to explain the story from a real human place of emotion. And that connects with a jury much more than an attorney just explaining facts and examples from his or her frontal lobes. So there's two examples. There's example of frontal lobe use and gut use or emotional center use. In addition, an attorney has to have the ability to read different people. So he or she has to read the judge's body language, how they're receiving what he or she is saying. They have to read the jury. They have to read witnesses. They have to interact with witnesses. So the simple social skills of what they're doing is sort of genius social skills, if you will. If an attorney is talking to a witness that is not their witness, this may be opposing counsel's witness, and that witness may not want to be cooperative, then the litigating attorney has to access parts of themselves that they wouldn't access to talk to, say, the judge.